131, State of Wisconsin versus Jacob Oyat. The state appears through District Attorney Kevin Schmidt in person. Mr. Oyat appears in person with his counsel, Nicholas Davis. We're set here today in this matter for a plea and sentencing. We also have 26 GF 28, but I believe Mr. Schmidt informed the court that that isn't going to.
Right out of the gate, this is a classic plea setup. One case gets dismissed, but read in at sentencing, meaning the judge can still consider it when deciding punishment. That's strategic. It reduces exposure, but doesn't erase behavior. Question for you. Is this mercy or accountability with a discount?
Be a non-prosecution case and to be dismissed and read in this matter?
Yes, as an uncharged read-on.
All right, thank you. And so the parties have reached an agreement. Mr. Davis, can you please recite the agreement for the record?
You can go ahead if you want.
What?
You can recite it if you want, Kevin. It's a misdemeanor battery, Your Honor, with a domestic. It's my understanding it's a year probation, court cost fine, DNA surcharging, whatever program is required, he has to do it.
That he needs his driver's license still?
He does.
Okay, all right. And it doesn't matter which one he's pleading to, aren't they both similar?
They're both similar, whichever one you wrote on there.
Whichever one I have on the sheet.
Yep, both cases on the sheet.
130.
130?
Let's do 130.
All right. So, Mr. Oyat, you went over a plea questionnaire waiver of rights form with your attorney, is that correct?
Yes.
And did he go over it thoroughly with you, essentially word for word?
Yes.
And you looked over that document and you signed it?
Yes.
And you understand everything?
Yes.
You are 26 years old, you have 12 years of schooling, you can read, write, you understand the English language, all correct?
Yes.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
This entire stretch is what lawyers call a plea colloquy. The judge is building a bulletproof record. Why? Because once you plead guilty, it's incredibly hard to undo. The court is making sure there's no confusion, no coercion, no "I didn't understand" later. This is a legal system locking in the decision.
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
No drugs, no alcohol, no mental illnesses or disorders?
Just mental health.
And do you take medication?
Yes.
And do you take it as prescribed?
Yes.
Does it interfere with your ability to comprehend or understand?
No.
So you're in a position right now where you fully understand everything.
Yes.
Now, did your attorney thoroughly go over your constitutional rights?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that you're pleading guilty in 25 CM 130 to count 1 misdemeanor battery with a domestic abuse modifier?
Yes.
Do you understand that the state would have to prove on or around July 21st, 2025, you caused bodily harm to AMD by an act done with intent to cause bodily harm to that person without that person's consent, a Class A misdemeanor? Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
You also understand that if you're not a citizen of the United States, your plea could result.
And here's something people overlook. That immigration warning. Even if someone is a citizen, judges must say on the record, it protects the plea from future appeals. Notice how methodical this is. Courtrooms aren't dramatic by accident. Every word serves a legal purpose.
In your deportation.
Yes.
You understand the agreement that's been recited on the record?
Yes.
And that it would be for a recommendation of 1 year of probation?
Yes.
Do you understand I'm not bound to follow that, meaning I can sentence you to any sentence that I believe would be an appropriate sentence?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yeah.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, the section called the probable cause section, where it basically says what happened and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did cause a misdemeanor battery without having AMD's consent.
Yes.
Are you guilty of this crime?
Yes.
Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or promises to you, Mr. Oyat, for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
I have a court date next month. Is that still ongoing?
With these actions,
No.
this should not, because with the new case that you were charged with, that's going to be dismissed as part of the deal, okay?
Okay.
All right, any other questions?
No.
Okay. Then as to count 1 in 25 CM 130, misdemeanor battery with a domestic abuse enhancer. But first, you understand with the domestic abuse modifier that upon conviction, you face a $100 additional surcharge,
Yes.
and you could face the federal prohibition to no longer being able.
That right there is huge. A domestic violence conviction triggers a lifetime federal firearm ban. Not 5 years, not 10, life, a misdemeanor, but consequences that follow forever. Do you think most defendants truly grasp that weight in this moment?
to use or possess a firearm for life?
Yes.
Okay. As to the misdemeanor battery with the domestic abuse modifier, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1 in 25 CM 130, the remaining count and the other open case, along with 26 GF 28, will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Victims' rights compliance.
Yes, Your Honor.
Any restitution requested?
In the report.
I don't think it was in
Penalties.
a,
Okay, in either case,
double checking this second one out. Our computer is just very slow. No restitution in any case.
okay, all right. Argument, Mr. Schmidt.
You can summarize what Mr. Oyat needs pretty easily. Alcohol ruins his life. Every single one of these cases, including his past cases in our county, has been him consuming alcohol and either starting a fight or engaging in erratic behavior that triggers someone to start a fight with him. One of those two. If he were actually able to stop consuming alcohol, I don't think we would ever see Jacob here ever again. That's why we need this probation. We need him to actually tackle that. The younger someone is when you start dealing with something like that, the more likely you're to be successful. And I think with him being only 26 years old, we have a good shot of that now.
Now the tone shifts. This stops being just a battery case and becomes an addiction case. The prosecutor isn't asking for jail. He's asking for structure. Probation isn't just punishment here. It's intervention. The real battle isn't in this courtroom. It's with alcohol. And at 26 years old, this might be his crossroads moment.
Thank you.
All right, thank you. Mr. Davis.
The DA is 100% correct. When he drinks, bad things happen. What really strikes me is I try and get the time to know all my clients as well as I can. And I got to talk to Jacob and I asked him questions as I would with all my clients. And he's to the point now that he's damaged his body. The doctor even told him if he continues drinking, he's going to die. His liver is that of some person that's been drinking their whole life, copious amounts. So his health is, it's not just doing silly and foolish things. It's now a matter if he wants to live and have a great life. He's young. He's 26 years old. When I talk to him, I guess I'm hopeful, but because of that and because he doesn't want to drink and because of all the problems that surrounded that, I hope that he can move forward. I know that there's issues that force a person to want to drink, and I know that he's dealing with that. A lot of things, that traumatic stuff that's happened in his past that he's explained to me. But he's an adult now. He needs to move on, and he's got to just work and not drink and enjoy his family and his life. And if he does those things, he's going to have a very gratifying life. But the health thing, that is just really shocking to me when he told me that he's that young and that he's already got those issues because of alcohol.
This is where it hits emotionally. We're no longer talking about fines or probation. We're talking about survival. A 26-year-old with liver damage described like a lifelong alcoholic. That reframes everything. The question isn't will he reoffend? It's will he live long enough to get another chance? And that's the tension hanging in this courtroom right now.
That was very shocking. And so the good side to this is he's an honest person. He's not a liar. He's been extremely polite, punctual, always for every appointment we've had or meeting or phone conference. And you can't meet a finer person. But again, Judge, I've never spent time with him when he's drinking. So, and I don't want to, because if he turns into a different person, then he's probably not pleasant and polite and intuitive. But what you see here right now is the person that I know, and he's a fine young man, and I think he's got an ability, and I think he will be successful. And so I sit here very proud of him right now, and I just hope that he pushes forward and really abstains from alcohol, not just because of a probation, but because he wants to live. Thank you very much, Your Honor.